5 and 7 and 20, 51 2, 54 7, 55 7, and 93 of regulations and guidelines. Paragraph 38 of the regulation provides as follows. Extensive, get a copy of the guidelines you see. Here we have to produce it in this judgment. From the foregoing provisions of the regulations and guidelines relied upon by the petitioners, it is clearly evident to me that although the Electoral Act has provided in Section 62, subsection 1, for the delivery by the presiding officer of the result along with other election materials under security and accompanied by candidates or their polling agents were available, such a person as may be prescribed by the first respondent. The first respondent has, by paragraph 38 of the regulations and guidelines quoted above, introduced electronic transmission to a collation system, in addition to the physical transfer of the election results to the registration area of ward collation officer. As stated earlier, the technological device as prescribed by ANIC in the conduct of the 2022 election is the bimodal voter accreditation system, BVAS. The function of the BVAS, as stated in paragraph 14A and 18A, is for verifying the voter through a positive identification of the voter and authentication of the voter by matching his or her fingerprints or face facial recognition, thus accrediting the voter to vote at the election and storing the data and number of such accredited voters. By paragraph 38, 2 and 3 of the regulations, the BVAS is also to be used by the presiding officer to upload a scanned copy of the EC8A to the ANEC result viewing portal, IREF, after which the presiding officer shall take the BVAS and the original copy of each of the forms to the registration area from ward collation officer. From the above functions of the BVAS, it is clear to me that apart from using the BVAS to scan the physical copy of the polling unit results and upload same to the IREF, there is nothing in the regulation to show that the BVAS was meant to be used to electronically transmit or transfer the result of the polling unit direct to collation system. It should be noted that the ANEC results viewing portal, IREF, is not a collation system. The Supreme Court in Oyetola and ANEC 2023, ANEC 23 LPELR, has explained the difference between the collation system and the IREF. In that case, AGIM JSC held as follows: court. As their names depict, the collation system and the ANEC result viewing portal are part of the collation process, the election process, and play particular roles in that process. The collation system is made of the centers where results are collected at various stages of the election. So the polling unit results transmitted to the collation system provides the relevant collation officer the means to verify a polling unit result as the need arises for the purpose of collation. The results transmitted to the result viewing portal is to give the public at large the opportunity to view the polling unit results on the election day. The community reading of the relevant provisions of the Electoral Act 2022, the regulations and guidelines for the conduct of elections 2022, and the ANEC Manual for Election Officials 2023 show that the Electoral Act provides in Section 62, subsection 1, that after recording an announcement of the result, the presiding officer shall deliver same along with election materials under security and accompanied by the candidates or their polling agents to such persons as may be prescribed by the Commission. The regulations and guidelines, as well as the ANEC manual, also state that hard copies of election results shall be used for the collation, and it is only where no such hard copies of the election results exist that electronically transmitted results or results from the IREF will be used to collect results. The petitioners who contend that ANEC was mandatorily required to electronically transmit the election results to the collation system have called PW2 as an expert witness who stated that he is a software engineer. He stated that he was aware that ANEC was mandated to electronically transmit or transfer the result from the polling unit direct to the collation system as prescribed by ANEC. He stated that the IRF portal is part of the technological architecture developed or deployed by ANEC for the storage, management, display, and uploading of polling unit results to be accessed by the public. However, under cross-examination, he admitted that he was not familiar with the operations and application of the Beavers machine, and that his investigations and findings were on the ANEC RF portal. He also agreed that it was only ANEC that could prescribe the method of transmission of election results. PW4 was also called as an expert witness by the petitioners, even though he stated that part of his brief by Labour Party was to determine ANEC compliance with the Electoral Act 2022 and the ANEC regulations and guidelines for conduct of the elections 2022. He prevaricated under cross-examination by the first respondent when he first stated that ANEC at the RF portal is an electronic collation system, but later recanted and said the RF portal is not capable of collating and or tabulating the results of an election. The witness also stated under cross-examination by the second and third respondents that it is the image of Form EC8A that will be transmitted to RF, while the hard copy of the Form EC8A will be taken to the Ward Collation Center. As for PW7, also called as expert witness by the petitioners, our evidence was basically in respect of the health status of Amazon Web Service, which hosted the ANEC RF portal. The testimony of PW8, the cyber security expert, also called by the petitioners, also related to the ANEC RF portal. On the part of the first respondent, RW1, Dr. Lawrence Bayode, the Deputy Director in the ICT Department of the first respondent, has testified that contrary to the assertion of the petitioners in paragraph 37 of the petition, there was no collation system of the first respondent to which polling unit results were mandatorily required to be electronically transmitted or transferred directly by the presiding officer. He stated that the prescribed mode of collation was manual collation of the various forms EC8As, EC8Bs, EC8Cs, EC8Ds, and EC8Es for the presidential election. He explained that the Beavers machine was designed to upload accreditation data at the end of the accreditation process and scan and transmit the results of the polling unit results through the e-transmission system to the IRF portal. Even as this witness was cross-examined by the petitioner's counsel, he was not cross-examined on his evidence that ANEC has not established any collation system to which results will be electronically transmitted from the polling units. Thus, his testimony on that fact remained unchallenged and uncontroverted. It is settled law that the court has a duty to act on unchallenged and uncontroverted evidence. The Bromwen Energy Trading Company Limited, OAN Overseas Agency, Ogunyade versus Oshunke, and others. In addition, RW2, called by the second and third respondents, had testified that the first respondent, through its chairman, made clarifications on 23rd of February 2023 that raw figures of election results will not be transmitted electronically by the first respondent, as such transmission was susceptible to hacking. He identified exhibits R24 and RA24 and RA25 as documents he referred to in his statement. These are the certified true copies of pages 28 and 27 of Tribune newspapers of 23rd February 2023, wherein the chairman made the said clarification. As indicated in our ruling on objections to documents, the petitioners did not object to the contents of exhibits RA24 and RA25, but only stated that they were objecting to the heading, but not the contents. We overruled that objection in our ruling because the reason advanced by the petitioners' counsel did not amount to a proper objection to those documents. Also noteworthy that the petitioners never cross-examined RW2 on his oral evidence and the said exhibits in support of his oral evidence. In exhibit RA24, the ANEC chairman was reported to have stated that raw figures will not be transmitted because the law does not allow for electronic transmission of results and because it is susceptible to hacking. He stated that only scanned copies of polling unit results will be uploaded to the RF for public view. From the evidence led by the parties on this issue, it is clear that apart from testifying that the first respondent failed to transmit scanned copies of polling unit results to the RF portal, none of the witnesses called by the petitioners had given evidence of the existence of any collation system to which the results shall be electronically transmitted by the presiding officers of the first respondent. Contrary to the contention of the petitioners that under the regulations it will not be possible to collect the presidential election results without verifying them with the electronically transmitted results, paragraph 92 of the same regulations categorically provides that at every level of collation where the annex copy of collected results from the immediate lower level of collation exists, it shall be adopted for collation. In addition, paragraph 48C of the regulations provides that if no result has been directly transmitted electronically for a polling unit or any level of collation, the provision of clause 93 of this regulation shall apply. The said clause 93 of the regulations, which I had earlier quoted, provides that where the annex hard copy of collected results from the immediate lower level of collation does not exist, the collation officer shall use electronically transmitted results or results from the RF portal to continue collation. And where none of this exists, the collation officer shall ask for the duplicate copies issued by the Commission to the Nigerian police or to the agents of political parties in that order. The foregoing provisions of the Electoral Act and the annex regulations clearly show that it is not correct, as contended by the petitioners, that results of the election cannot be validly collected without the electronically transmitted results. Indeed, the regulations primarily provide for manual transmission or transfer and collation of results. There is nothing in the Electoral Act or the annex regulations and guidelines to show that an electronic collation system was prescribed by the Commission to which results will be electronically transmitted. Thus, the petitioners were unable to establish the assertion that the first respondent is mandatorily required to electronically transmit the polling unit results to a collation system. The first respondent, on the other hand, has adduced unchallenged evidence that apart from the annex RF portal, no collation system was established by the first respondent to which the result of the presidential election must be electronically transmitted for collation. It is therefore my finding that both the Electoral Act and the regulations and guidelines provide for manual collation of election results, and the electronic transmission to a collation system apparently introduced by the first respondent in the regulations and guidelines are not mandatory as contended by the petitioners herein. Also, my finding based on the evidence adduced that the only collation system put in place by the first respondent in the conduct of the presidential election is comprised of the physical collation centers in the registration areas or ward collation centers, local government area collation centers, state collation centers, and the national collation centers elaborately stated in paragraphs 47, 50, 53, 54, and 55 of the regulations and guidelines for the conduct of elections 2022. With regard to the petitioner's contention that the first respondent deliberately failed to upload the presidential election results to the annex result viewing portal, RF real time, the petitioners averred in paragraphs 53, 97, and 98 the petition that the petitioner also 53. The petitioner also contend that in manifest violation of the first respondent regulations and the Electoral Act 2022, the results of the presidential election held in the polling units were not fully uploaded on the RF as at the time of the purported declaration of second respondent as the winner of the presidential election, which gave room for manipulation of the said results by officials of the respondent. 97. The first respondent, via a written communication, sought to excuse the manifest non-compliance with the requirements of the Electoral Act 22 and the regulations by claiming that there were glitches in the electoral system which prevented it, that first respondent, from uploading the results of the presidential election from the polling units to the RF portal on the day of the election. The said written communication is hereby pleaded. 98. The petitioner shall contend that the alleged glitches that the alleged glitches in the electronic system installed and managed by the first respondent were a ploy invented by the first respondent to credit unlawful votes to the second respondent and thereby wipe out a clear advantage which inured to the petitioners following the lawful exercise of voting rights by the electorate. In response to the above allegation, the first respondent adverted in paragraphs 59, 55, 7, 8, 9, and 10 of their reply to the petition. That's, I will reproduce them here. In paragraph 37 of their reply to the respondent's reply, the petitioners have again denied that there was any technical glitch and maintained their assertion that the failure to upload the results on the IRF was a ploy by the first respondent to manipulate the results. They stated that they will rely on the server logs and server contents of the IRF hosted on the AWS cloud platform to show that the results of the election were uploaded on the IRF portal, but the first respondent attempted to delete or remove the uploaded results. It is true that a petitioner who alleges non-compliance with the Electoral Act has the legal burden to establish such non-compliance and show how the non-compliance substantially affected the result of the election. Ladoja and Ajimwabi, Shinkafi and Yari, in proof of their assertion, the petitioners subpoenaed PW7 and PW8 as expert witnesses, but the respondents challenged their competence to testify because their witness statements on oath were not founded along with the petition, as mandatorily required by paragraph 45 of the first schedule to the Electoral Act. In my ruling at the earlier part of this judgment, I had upheld the respondents' objection and served out the evidence, which include their witness statements on oath and the documents and or reports tendered through them. These are exhibits PCJ-A to F, PCJ-4, 6 reports of AWS health dashboard status and certificate of compliance tendered through PW7, and exhibit PCK1, metadata admitted through PW8. However, notwithstanding that position, I shall proceed to consider the evidence of PW7 and PW8 and the other witnesses called by the petitioners. PW7 claimed to be a cloud engineer or architect, an employee of Amazon Web Services. She stated that she is not only a member of the Labour Party, the petitioner is in, but she contested election as a candidate for member House of Representatives for Ogoja, Yala, Federal Constituency of Cross River State. He stated that for an IT application, the SDLC includes requirement gathering, analysis, and design. Population centers and design, yes. The development from implementation, testing the code, staging the software and development and deployment. He stated that she was aware that at the process of testing and staging of software code and problems or challenges, any problems or challenges with the software will usually show and or be flagged. He stated that each function is supposed to be tested and any issues flagged ought to be remedied before deploying the software. He stated that if a software from application has any glitch, such a glitch will pop up. That is flagged at the testing stage. He stated that from her preliminary review of the public viewing facing the RF website, she is aware that the polling unit results images are stored in Amazon S3 and AWS storage service. He stated that as an employee of AWS, the AWS has a service level agreement, SLA, with its customers, which is accessible to the public on docs.aws.amazon.com, and that by the SLA for S3 service, it is designed to provide 99.999% durability and 99.99% availability of objects stored over a year. He said this is accessible to the public on http docs.aws.amazon.com, Amazon S3 latest user guide data durability.html. He stated that the AWS code servers are hosted in 33 regions. The health status of AWS cloud service for all regions for the past 12 months from date is accessible to the public on http://health.fws.amazon.com health/status. It stated that the health status of each service in each region on February 25, 2023 indicated that there were no glitches on any of the AWS cloud servers. It stated that from the post-event summary is by AWS, the last time a significant outage occurred on the AWS cloud servers was on December 10, 2021, which was an internal connectivity issue that affected EC2, API, and Container API, among other services access issues affecting only one region. He said this is available to the public. AWS 7 stated that she was aware that a glitch in a software means a malfunctioning, as a result of which the application is not able to perform properly, and that fixing a glitch in a software application by the creation of patches refers to a series of changes made into the system by writing small code, which is imputed into the software to change its current state and thereby function properly. On cross-examination by the first respondent, PW7 admitted that she missed production maintenance, which is an important element of software development life cycle. He denied that glitches occur at post-production maintenance stage and stated that it appears at the testing stage. He stated that she was aware of personal health dashboard, but stated that the first respondent's personal health dashboard is not before the court. He admitted that the AWS adopts a shared responsibility model in which AWS plays its part while the customer plays its own part when it comes to security. He admitted that the report that only shows the health status of all AWS services in all regions in terms of the infrastructure and not security. He admitted that in order to know what happened on applications deployed on AWS infrastructure by a customer, it is not necessary to get a technical report. PW7 also stated that she is familiar with AWS CloudTrail, and there is a CloudTrail for every AWS account and for every API action made on that account. She admitted that she did not produce the CloudTrail for any deployed application before the court. He denied that the CloudTrail is the best account of what transpired on any deployed application, but did not state the best way to know what transpired. He stated that it is highly unusual for glitches to occur for primary functions of applications in production. He stated that she was not aware that glitches happened with the Central Bank of Nigeria e-money project, or the one that happened with the MTN Mono PSG. He admitted that she was a candidate for the Labour Party at the last election. She also admitted that the subpoena under which she came to court was served on her personally and not on Amazon Web Services. Also on cross-examination by the second and third respondents, EW7 admitted that Exhibit PCJ2, which she presented as her employment verification letter, was not signed by anyone, but insisted that there is the name of Employment Resource Center written on it. She also admitted that she had been attending the court and watching the proceedings before the day of her testimony. She admitted that the report she presented before the court is public information posted by Amazon and that it is available and accessible to the public. She, however, insisted that the report is hers because she was the one who downloaded it, brought them to the court. PW7 also admitted under cross-examination that she won primary election for her constituency under Labour Party, the second petitioner, and that she even filed an action against ANIC because she was not placed on the final list of candidates published by ANIC. She admitted that her complaint was because she tried several times to upload her information on INEC's side, but all her efforts failed because of network failure. She admitted that network failure can happen to either end of an application, even as she disagreed that there was a glitch on INEC's side. She admitted that in her affidavit. She stated that INEC's site crashed. EW7 also stated that she was aware that EWS experienced outage of several hours on Tuesday, 28 February 2017, and that as at 2021, AWS also was reported to have suffered more than 27 outages. He also admitted that what was sent to RF was the image of the form EC8A. On cross-examination by the fourth respondent, PW7 stated that she did not know about password protocols and cannot speak about password protocol to modify the applications of INEC. She admitted that the open cross-access information she downloaded in her report cannot be amended by her. In fact, she admitted that she was not representing Amazon Web Services in this case. However, insisted that she is an expert. She stated that she was aware of glitch which affected Japan brokers in September 2021, but stated that the last one she was aware of was in December 2021. As to whether glitches can happen again, she stated that anything is possible. In his evidence, PW1, Dr. Chibike Ugoike, another expert witness called by the petitioners, stated that he is a cybersecurity and risk advisory consultant and that he was approached by the Labour Party to provide expert evidence in this petition. He said he had read the Electoral Act 2022 and the INEC regulations and guidelines for the conduct of elections 22 and the INEC Manual for Election Officials 2023, with particular attention to the relevant provisions dealing with uploading and transmission of election results from the polling units using the beavers to IRF portal. He stated that he has also read the petition as well as the reply to the petition filed by the first respondent. He stated that from his reading of those documents and processes, when a software application undergoes the required minimum testing for deployment, any functionality error or bug will be flagged. He stated that the purpose of testing is to remedy or resolve such errors before the application is deployed for production. On cross-examination by the first respondent, PW8 stated that he was approached on 10th March 2023 and he finished his work sometime in May 2023. He said that he did his preliminary report on 17th and 18th March. On 17th and 18th March 2023 and concluded the final report at the end of May 2023. PW8 stated in paragraph 14 of this his adopted written witness statement that he read the petition and the first respondent replied to the petition in doing his work, stated that he could not recall whether he read the petition. But when his attention was drawn to paragraph 14 of his statement, he agreed that he had read those pleadings. He admitted that it is not impossible for errors to occur after deployment of technology or application. When referred to paragraphs 22 and 23 of his statement, he stated that he referred to the metadata on the IRF in 3 polling units to establish that it is possible to show metadata. He stated that there were errors in those polling units and he did not have to examine the physical copies of the forms EC8A of those polling units. He stated that from the tabulation of the metadata, he could not tell that whether the results stated in those polling units were collected. He stated that all the work he did was on his computer. He confirmed that the AWS security model is a shared responsibility model between AWS and the client. He stated that he was aware of the cloud trail and confirmed that the cloud trail will explain the availability of the application of INEC on the AWS infrastructure. PW8, who insisted that there was an electronic collation system, only pointed to an upload at the last paragraph of Exhibit TCK2 and stated that it means an electronic collation system. When cross-examined by second and third respondents, PW8 denied that it was part of his brief to assist the Labour Party to respond to the respondent's reply. He admitted that he did not inspect any of the beavers' machines and did not interrogate Festus Okoye, whose statements he referred to. He confirmed that Exhibit A, which he attached to his report, is the metadata of 23 pages showing multiple uploads. He denied that it contains information which are coded and not explained, and insisted that the information he provided are decrypted and readable. He admitted that he supplied some links in some paragraphs of his report, but stated he did not expect the court to go and browse, access, and download the information contained from those links. When cross-examined by the first respondent, PW admitted that he downloaded the 12 polling unit results he attached to his report from the IREF, and he did not interact with the presiding officers of those polling units and did not see the hard copies of those results. He could not also tell whether those results have been collected. Starting with the evidence of PW7, it's evidence that she is a person who has an interest to serve in this petition, being a member of the second petitioner, under whose platform she contested election for House of Representatives. Her interest in this petition is further underscored by her admission that she had been attending court and watching the proceeding prior to making her statement on oath and testifying as a witness. Her testimony, therefore, was essentially a demonstration of her support and loyalty to the second petitioner. Her claim to being an employee of Amazon Web Services is also suspect, as she produced no credible evidence to that effect. Exhibit PCJ2, which is the paper she presented as evidence of her employment by AWS, is obviously a worthless paper. It has no author, although she insisted that the author is Employee Resource Center. The paper was also not signed. Her evidence adds no value to the petitioner case because she stated that her evidence relates to the health status of AWS in terms of infrastructure and not in terms of security. She had admitted that the expert report in Exhibit PCJ 3A to F, which she brought to court, are actually documents publicly available on Amazon website, which she downloaded, and her only claim to its ownership is that she was the one who downloaded it and brought it to court. She even admitted that she could not add or subtract anything from the reports. Those reports are obviously not her own. She also admitted that the health status of the first responders application posted on the AWS is not before the court. Her conclusion on the totality of this witness is that it is devoid of any probative value. As for PW8, he has demonstrated that he worked to an answer. Not only did he admit that he read the petition and reply of the first respondent in the course of his commission work, he also stated that he read the Electoral Act and annual regulations and manual for election officials. On the authority of Ladoja and Ajimobi, the evidence of this witness is also not of any probative value. Apart from the above, the other witnesses or petitioners, especially PW4, PW9, 10, 12, and 13, all stated that they voted and everything went well in their respective polling units. In particular, PW4, PW10, and 13 all stated that their polling unit results were taken to collation centers. Therefore, even the evidence of the petitioner witnesses showed that the polling unit results were physically taken to the registration areas for work collation centers. The petitioners have left no evidence to establish the existence of any collection center to which the potential election results were to be electronically transmitted for collation. On the part of the first respondent, RW1 testified that the failure to upload some of the results of the presidential election to the IREF portal real-time on 25th February 2023 was due to a technical glitch experienced on their e-transmission system. RW1, through whom the first respondent tendered exhibits RA6 and RA7, stated that at the end of the polls, in some polling units, on 26 February 2023, it was observed that the first respondent by the first respondent that polling unit results being uploaded to the annex e-transmit system by the presiding officers were pushed to the Senate and House of Representatives modules on the IRF, but the results of the presidential election were not being pushed to the presidential model on the IRF. That based on threat levels and reports by security agencies that the first responder servers may be subjected to attacks on election day, the first responder first course of action was to investigate whether the servers were being attacked. The preliminary investigation showed that there was no attack, but the issue was a HTTP 500 error from which the application, within the application, which are mostly errors due to problems of configuration, permissions, or failure to create application resources correctly. That a thorough investigation revealed that the e-transmission was unable to map the uploaded results of the presidential election to any specific state, and that the presidential folder structure, which was meant to organize the uploaded result sheets in order of election, state, local government, area, ward, polling unit, was causing the application to crash and return as server error whenever it tried to create the folder structure for the presidential election. RW1 explained that creating a folder structure to organize the uploaded results in the hierarchy of election, state, local government, ward, and polling unit was a new feature introduced as an improvement in the transmission system. And that the old system randomly saved uploaded results by timestamps, making it difficult to upload result sheets by election or by state. He stated that the deficiency was observed after the Ocean State governorship election in 2022. RW1 stated that during the election of 25th February 2023, the application was able to query and detect the base states for the senatorial districts and federal constituencies based on the mapping of all central districts and federal constituencies to their respective states. And that this mapping still exists in the database. And the upload was successful because it was able to identify the state and build the folder hierarchy for the results organization. But for the presidential election, the application crashed because the presidential election does not belong to any state on the first respondents database, and any attempt by the application to build a folder structure to organize the election results failed with the HTTP error response. RW1 stated that since these were live servers that were being used for the election, extra care was taken not to cause a complete outage, and four application patches or updates were created and deployed immediately with the aim of fixing the HTTP error. He stated that the first presidential election results were successfully uploaded at 8:55 p.m. on the 25th February 2023. He further stated that to confirm that the glitch actually happened, as well as the time that all patches to fix the error were created and deployed, can be viewed on AWS Cloud Trail and AWS functionality that allows enabling operational and risk auditing. He added that all actions taken to fix the error are recorded as events in the Cloud Trail logs. Stated that the technological glitch experienced on the e-transmission system was not a ploy to manipulate the election, and the glitch did not affect the results of the election. He then tendered exhibits RA6 and RA7, the Cloud Trail log, and his certificate of compliance with Section 84 of the Evidence Act 2011, and identified same as the documents he referred to in his witness statement on oath. Under cross-examination by the petitioners, RW1 confirmed that testing was carried out on the e-transmission system, the first respondent, on the 4th February 2023, before it was deployed and a report was issued. When shown a report produced on subpoena, he identified same as a report on vulnerability assessment and penetration testing data, dated 22nd February 2023, but stated that it was not the report of testing carried out on the e-transmission system, 4th February 2023. The petitioners then tendered the report of vulnerability assessment and penetration testing through its witness, which was admitted as X1. From the evidence adduced on this point, it is clear that the petitioners are unable to substantiate their contention, the burden of proof of which was on them by virtue of Section 131, subsection 1 of the Evidence Act 2011. They have failed to establish that the first respondent had deliberately failed to upload the results of the presidential election to the RF in order to manipulate the results in favor of the second respondent. The first respondent, on the other hand, has offered credible evidence in the form of Exhibits RA6 and RA7 to show that its e-transmission application posted on the Amazon Web Services, which is supposed to upload the results of the presidential election to the RF, has suffered a glitch on the election day on 25th February 2023. On the preponderance of evidence, I am convinced that the petitioners have failed to establish their assertion that the first respondent had deliberately failed to upload the results of the presidential election to the RF in order to manipulate the results in favor of the second respondent. As I stated earlier, the electronic transmission system of electronic transmission of results of an election is not expressly stated anywhere in the Electoral Act, but was only introduced by the first respondent, that is ANIC, in its regulations and guidelines 2022, and in the ANIC Manual for Election Officials 2023. By Section 134, subsection 2 of the Electoral Act 2022, only an act or omission which is contrary to the Electoral Act 2022 can be a ground for questioning an election. Thus, complaints relating to non-compliance with provisions of the regulations and guidelines or the manual of election officials are not legally cognizable complaints for questioning an election. In interpreting Section 138, subsection 2 of the Electoral Act 2010, which is similar to Section 134.2 of the Electoral Act 2022, the Supreme Court held in Nyesom and Peterside as follows. Quote, the above provisions appear to be quite clear and unambiguous. While the Electoral Commission is duly conferred with powers to issue regulations, guidelines, or manuals for the smooth conduct of elections, by Section 138.2 of the Act, so long as an act or omission regarding such regulation or guideline is not contrary to the provisions of the Act itself, it will not of itself be a ground for questioning the election. See also Jegede and INEC. Since, as shown above, the electronic transmission of election results is not specifically provided for in the Electoral Act 2022, but was only provided for in the regulations and guidelines for conduct of elections 2022 and INEC Manual for Election Officials 2023, the failure to electronically transmit election results cannot be made a ground for challenging an election under Section 134, subsection 1b of the Electoral Act 2022. The petitioners also allege in paragraph 59 of the petition that the first respondent failed to record in the prescribed forms the quantity, serial numbers, and other particulars of result sheets, ballot papers, and other sensitive electoral materials on the prescribed forms EC 25A, EC 25A1, EC 8B, and EC 8B1. That is to say, electoral materials received for local government areas, electoral materials distribution for registration areas, electoral materials received for local government areas, electoral material distribution for RAs, electoral materials received, reverse logistics, and polling unit materials in respect of states where the respondent is purported, where the second respondent purportedly won. The petitioners further allege that following the order of court for inspection, they applied through their campaign organization and lawyers for the forms, but the first respondent refused to give or issue those forms and refused to allow the inspection of the forms despite the order. In response to the petitioner's allegation, the first respondent countered that its officials duly recorded in the prescribed forms the quantity, serial numbers, and other forms, other particulars of the result sheets, ballot papers, and other sensitive electoral materials in the prescribed forms EC 25A, EC 25A1, EC 8B, EC 8B1, in respect of the states where the second respondent duly won the election, as done in the states where the petitioner won the election, as the procedure adopted in the election across all the states of the Federation are uniform and the same. The first respondent further stated that it duly complied with the order of inspection granted by the Honorable Court, and the petitioners were not denied access to the EC forms EC 25A, EC 25A1, EC 8B, EC 8B1 as alleged by the petitioners. It was the subordinate senior counsel with regard to the state of the pleadings and the issues of fact in contention. The onus is on the first respondent to prove that there was indeed due compliance with the provisions of Section 73, subsection 2 of the Electoral Act, since petitioners are asserting the negative, while the respondents are asserting the positive. They relied on the decision of this court in First Bank Nigeria PLC, Adjacent Business Investments, and Royal United Nigeria Sterling Bank PLC, submitted that the first respondent did not lead any evidence in proof of their positive assertion there was compliance with the state provision of Section 73, subsection 2 of the Electoral Act. Learned Counsel submitted that on the part of the petitioners, they have led evidence through PW12 that the petitioners obtained order of this court for inspection of documents, but the first respondent had refused to produce the forms, despite several letters demanding the forms from the petitioners, which were tendered as exhibits PCQ1 to PCQ6. He added that the petitioners have also served subpoena duces tecum on the first respondent to produce the said forms, but the officer of the first respondent, the deputy director, certification, complaints, and legal drafting, who came to court in answer of the subpoena on 20th June 2023, failed to bring the forms. Counsel asked the court to invoke the provision of Section 167E of the Evidence Act against the first respondent and hold that the forms, if produced, would have been unfavorable to the first respondent. He further submitted that the non-compliance with Section 73(2) of the Electoral Act has been established, which has invalidated the election in those states which the second respondent was declared to have won, namely Benue, Borno, Ekiti, Gawa, Kogi, Kwara, Niger, Ogun, Ondo, Oyo, Rivers of Zamfara states, which are shown in the form EC8DA, admitted in evidence as Exhibit PBF. He pointed out that Section 135, Section 1 of the Electoral Act 2022 only deals with non-compliance generally, but Section 73, Subsection 2 of the Act has provided a specific effect of non-compliance with provisions. Relying on Crown's Townsend Organization for the National Institute of Policy and Strategic Studies, he urged the court to hold that substantial non-compliance has been established by the petitioners. Arguing per contra, Learned Senior Counsel for the first respondent referred the court to Section 135(1) of the Electoral Act 2022 and submitted that the petitioner complained of non-utilization of prescribed forms, even though not proved, cannot without showing the effect on the election be a basis to avoid an election. He submitted that the attempt by the petitioners to exclude Section 73, subsection 2 of the Act from the ambit of Section 135, Section 1 is a non-starter because the non-compliance referred to in Section 135(1) is for the provisions of the Act, and no part of the Act was excluded by the section. He posited that for non-compliance with Section 73 of the Act to avoid an election, it must have substantial effect on the election, and the petitioners have neither proved such non-compliance nor shown that it has substantially affected the result of the presidential election. I urge the court to so hold. Petitioners had contended that since they are alleging that the first respondent failed to record in the prescribed form the quantity and particulars of the materials used in the election, they are alleging the negative, and as such, the burden is on the first respondent to establish that they have duly complied with the provisions of Section 73 sub 2 of the Electoral Act. They have relied on the decision of First Bank of Nigeria versus Adjacent Business Investment Limited, Royal United Nigeria for Sterling Bank. While it is true that the burden of proof is generally on the party that asserts the affirmative for an issue and not on the party who asserts the negative, there is an exception to that general principle. Where a negative assertion forms an essential part of the party's case, the burden is on him to establish that fact. This position was clearly stated by the Supreme Court in the case of Buhari and Anik, where Toby JSC stated held thus, quote, a negative allegation must not be confounded with the mere traverse of an affirmative one. The true meaning of the rule is that where a given allegation, whether affirmative or negative, forms an essential part of a party's case, the proof of such allegation raised on him, close of court. Again, this court in Dashi and others versus Druven and others espoused this legal position when Ugo JCA held as follows. Quote, I am in no doubt that this argument of appellants about negative and positive assertion is misconceived. For while it is true that the burden of proof is generally on the person who substantially affirms the positive of an issue and not on the person who makes a negative assertion, there is a caveat to that principle to the effect that where a negative assertion forms an essential part of a plaintiff's case, as it evidently is the case of the appellant, the burden of proof of such allegation rests on him. The law on this point was lucidly stated by Bowen LJ and Abrath, was a Northeast Railway Company, 11 Queensbend Division 440 at 457, when he said that, quote, in an action for malicious prosecution, a plaintiff has the burden throughout of establishing that the circumstances of the prosecution were such that the judge can see no reasonable and probable cause for instituting it. In one sense, that it is the assertion of a negative, and we have been praised with the proposition that when a negative is made out, the onus of proof shifts. That is not so. If the assertion of a negative is an essential part of a plaintiff's case, the proof of the assertion still rests on the plaintiff. The terms negative and affirmative are, after all, relative and not absolute. Close of court. In the instant case, the petitioners have made their allegation of non-compliance with Section 73(2) of the Electoral Act 2022 by the first respondent as an essential part of their case in challenging the results of the election declared by the first respondent. Not only are the petitioners statutorily required by Section 135, subsection 1 of the Electoral Act to establish substantial non-compliance with the provisions of the Act, they are required to show how such non-compliance has substantially affected the result of the election. As rightly observed by the learned senior counsel for the first respondent, the non-compliance that will not invalidate an election under Section 135(1) unless it is shown to be substantial and to have substantially affected the result of the election encompasses non-compliance with all provisions of the Electoral Act, including Section 73, subsection 2 thereof. In other words, Section 73, sub 2 is not derogated from the ambit of Section 135, section 1 of the Act. Indeed, in Buhari and Anik, Toby Joyce, while considering Section 145(1) of the old Electoral Act, similar to Section 135(1) of the Eastern Electoral Act 2022, had held at page 48, paragraphs B to D that, quote, a petitioner who files a petition under Section 145(1) of the Electoral Act has the burden to prove the ground or grounds. This is because he is the party alleging the grounds and he has a duty to prove the affirmative. He is the party who will lose if no evidence is given on the grounds. If the party does not prove his case under Section 145(1) of the Act, the action fails. Therefore, the petitioners who have alleged non-compliance with the Section 73, subsection 1, as part of their course of action, have the burden to establish that non-compliance in accordance with the requirements of Section 135(1) of the Act. The petitioners have also relied on the evidence of PW12 and on exhibits PCQ1 to PCQ6, also tendered through PW12. The exhibits are acknowledged copies of letters dated 6 March 2023, 14 March 2023, 16 March 2023, and 20th March 2023, all written by the petitioners or their solicitors to the chairman of the first respondent, demanding for inspection of documents and for certified true copies of the electoral forms. The petitioner also relied on subpoena duces tecum served on the first respondent to produce the said form. In his testimony at paragraph 58 to 60 of his adopted written statement on oath, PW 12 merely stated that the petitioners made several applications through his campaign organization and solicitors for certified copies of election documents and data relating to the presidential election, but they were denied by the first respondent, and that the first respondent had failed to record in the prescribed forms the quantity, serial numbers, and other particulars of result sheets, ballot papers, and other sensitive electoral materials. The record of proceedings of this court also shows that at the instant of the petitioners, subpoenas dated 30th May 2023 and 13th June 2023 were issued on the chairman of the first respondent to produce some documents. The record also shows that on the 20th June 2023, one Olu Finmilayo Taiwo, the Deputy Director of Certification on Complaints and Legal Drafting with ANIC, appeared on behalf of the first respondent in answer to the subpoena duces tecum. While she produced some of the documents required of the first respondent in the subpoenas, he informed the court that the documents listed in the subpoenas as listed E, C, D, and E are in the states, and since the subpoena was served on them just before the previous day, it will take some time for the first respondent to get them. An examination of exhibits PCQ to PCQ6, which were tendered by the petitioners through PW12, showed that all except exhibit PCQ are letters addressed to the chairman or the first respondent by the petitioners and their solicitors requesting for inspection of documents and for certified copies of those documents. Exhibit PCQ4 is a covering letter addressed to the resident electoral commissioner, Benue State, from the law firm of Dr. Paniechi Piazzo, SAN and Co., notifying the respondent of the resident electoral commissioner of subsequent action on the solicited letter by the National Chairman, ANIC Headquarters, Abuja, dated 6 March 2023. It is instructive to observe that Section 74(1) of the Electoral Act 2023 mandates the resident electoral commissioner in a state where an election is conducted within 14 days after an application is made to him by any of the parties to an election petition, cause a certified true copy of such document to be issued to the said party. Subsection 2 of that section even provides that any resident electoral commissioner who fails to comply with subsection 1 commits an offense and is liable on conviction to a maximum of 2 million naira or imprisonment for a term of 12 months or both. A look at the letters exhibits PCQ1 to PCQ6 showed that they were all addressed to the chairman of ANIC instead of the resident electoral commissioners in the states, as required by the petitioners by Section 74, subsection 1 of the Electoral Act 2023. It is therefore clear that the petitioners have failed to follow the clear legal procedures of requesting for those documents. Also, when the record shows that the subpoenas, which they claim to have served upon the first respondent, were also served on the chairman of the first respondent, and as stated by the officer who answered the subpoena, same was served only the previous day for her appearance in court. From his evidence, PW12 had stated that apart from voting at his polling unit 04 at Dawaki, Abuja, the only role he played in the 25th February 2023 general election, presidential election, was that he was a member of the second petitioner's special room. And on cross-examination by the respondent, he stated that he was neither a polling agent nor a collation agent. His evidence that the first respondent had failed to record in prescribed forms the quantity, serial numbers, and other details of the electoral materials can only be hearsay evidence, which has no probative value. Also, the mere production of exhibits PCQ1 to PCQ6 cannot establish an allegation of non-compliance with Section 73(2) of the Electoral Act. The Electoral Act 2022 Apart from the evidence of PW12 and exhibits PCQ1 to PCQ6 tendered through him, the petitioners have produced no other evidence to substantiate their allegation that the first respondent failed to comply with the provisions of Section 73, Subsection 2 of the Electoral Act 2022. Rather, PW10, Kefas Iya, the supervisory presiding officer for Madagali Ward in Adamawa State, who was subpoenaed by the petitioners to testify on their behalf, has stated in paragraphs 4 and 5 of his witness statement of oath that as a presiding officer, he reported to the local government area INEC offices in Gulam, Madagali local government area in Adamawa State, on the 24th February 2023 to collect the sensitive and non-sensitive materials for the 25th February presidential election and National Assembly elections, and that after collecting the materials, he proceeded together with security agents and other INEC officials, which consisted of presiding officers, assistant presiding officers 1, assistant presiding officer 2, and assistant presiding officer 3 to Madagali Ward that evening to the registration area. His evidence was also to the effect that on the day of the elections, everything went well, and after sorting and counting the votes, the presiding officer did the entry and snapped the results with beavers for the upload and transmission of the results to the INEC portal, but were unable to upload. And when they complained to him, he requested them to come to the registration area. It is therefore clear from the above that the petitioners were unable to establish the allegation of non-compliance by INEC with Section 73(2) of the Electoral Act 2023. The evidence PW2 and exhibits PCQ1 to PCQ6 have not been able to rebut the presumption of regularity, which inures to the first respondent under the law, which can only be rebutted with cogent and credible evidence, PAPC and Sheriff and others. From the totality of the evidence adduced on this issue, I am of the considered view that petitioners have failed to prove substantial non-compliance with the provisions of the Electoral Act 2022. 2 is therefore resolved against the petitioners and in favor of the respondent. Issue 3 is whether from the totality of the evidence, the petitioners have proved that the presidential election held on 25th February was invalid by reason of corrupt practices. Here again, we have considered the submissions of counsel. So in their petition, the petitioner made allegations of suppression of scores, unlawful reduction and inflation of results, uploading of fictitious results, misrepresentation and manipulation of results where no election took place, overvoting and wrong computation of results. These allegations are contained in paragraph 60, 78 for the petition. In paragraph 60, 61, 62, 64, 65, 68, and 69 of the petition, the petitioners allege that due to the first respondent's refusal and neglect to upload and transmit the result of the election to the IRF on the day of the election, the first respondent suppressed the actual scores obtained by the petitioners. According to them, the suppression of the first respondent scores, which occurred in 18,088 polling units, was orchestrated by the first respondent, deliberately uploading readable and blurred forms EC8S on the RF, and thereby suppressed the lawful scores obtained by the petitioners in the safe polling units. He further alleged that in Rivers State, during the collation exercise, the first respondent announced scores of the petitioners as 175,071 votes, and the second and third respondents as having 231,591 votes, when in actual fact, the petitioners' lawful votes are 205,110, while that of the second and third respondents ought to be 84,108. They similarly allege that in Benue State, the first respondent suppressed the lawful votes obtained by the petitioners, when it announced their votes as 308,372, and that of the second and fourth respondents as 310,408, when the actual votes of the petitioners were 329,000, and that of the second and third respondents at 300,421. The petitioners also alleged that the first respondent was purporting to upload the result of the presidential election on the IRF, embarked on massive misrepresentation and manipulation by uploading fictitious results in polling units where there were no elections, as well as uploading incorrect results. They stated that if the results of polling units, votes, local government states are properly tabulated and calculated as required by the Electoral Act and the regulation and guidelines for the election, the overall results of the election and the percentages scored by the political parties will show that the petitioners won the presidential election of 25th February 2023. He stated that the petitioners should rely on a report of inspection of the electoral materials. In the earlier ruling of this court on the preliminary objections raised by the respondents on the propriety of the averments contained in the petition, we held that apart from the allegations of inflation and reduction of votes in Rivers and Benue states, where the petitioners have stated the figures alleged to be inflated and reduced, the other allegations of the petitioners were nebulous and bereft of the material particulars. We held that the said averments contain no particulars of the polling units where the alleged infractions took place or the figures alleged to have been inflated or reduced. We had struck out those paragraphs for offending paragraph 4, 1D, and 2 of the first schedule to the Electoral Act 2022. Indeed, apart from the strict requirement of stating material particulars in election petitions, it is also tried that in civil litigations, including election petitions, whenever fraud or any other crime is alleged, material facts of such allegation of fraud or other crime must be pleaded and clearly set out. The Omoborio and others was adjusting, Yeso Limited and Honey Legion, Lorin and others versus Tangolana, others. The petition allegations of suppression of votes, inflation and reduction of votes, massive misrepresentation and manipulation by uploading fictitious results all amount to falsification of results of an election. This Sabija versus Tukur. The Supreme Court held that allegations of inflation with non-existing votes is another way of alleging falsification of results. Indeed, in Haruna and Modibo, the Supreme Court held that where a petition is based on allegation of incidents of fraudulent acts, manipulation of results, or falsification of results, that allegation is criminal in nature, and evidence required in proof thereof must be clear and unambiguous. In other words, the proof must be beyond reasonable doubt. This section 135 sub 1 of the Evidence Act and cases of Buhari and Obasanjo, Emmanuel Umana, Ipiazu, Oti, Abubakar, and others versus Yaradua, Omishore, Aribashola, Magaji, and All Progressive Congress. In order to establish falsification of election results, the petitioner must produce in evidence two sets of results, one genuine and the other false. In the cases of Kaki and PDP, Mobodo and Ono, Adewale and Olaifa. Also Chima Anoze versus Dr. Ken Obichere and others. And Joseph Olujimi Kolawole Abaje versus Babatunde Raji Fashola. The Okichuku and another versus Onyebu. To prove their petition, the petitioner also, who indicated during pre-hearing, they will call 50 witnesses, call only 13 witnesses. They are mentioned here. Of the above 13 witnesses, only 3 had their witness statements on oath filed along with the petition. These are PW1, PW2, and PW12. In our ruling on the respondent's objection to the competence of the petition witnesses at the beginning of this judgment, we had struck out the evidence of PW3, 4, 5, 6, 7, 8, 9, 10, 11, and 13 on the ground that their witness statements on oath were not filed along with the petition as mandatorily required by paragraph 45B of the first schedule to the Electoral Act. However, even if the statements of those witnesses of the petitioners were to be considered, the question is, are those testimonies cogent and credible to establish the petitioner's allegations stated above? PW1's testimony was only on the alleged double nomination of the third respondent and feature proceeding, which we have already determined above. Even as he stated that he voted in his polling unit during the election, he stated that he did not play any other role in the elections beyond exercising his civic responsibility. As for PW2, who said he was a software engineer, he stated that upon his reading of the relevant provisions of the Electoral Act and annual regulations, he is aware that the presiding officer in the polling unit is mandated to electronically transmit or transfer the result of the election direct to the collation system as prescribed by ANEC, and to also use the beavers to upload a scanned copy of the polling unit result sheet to the ANEC result viewing portal RF, prescribed by ANEC. He said, from his knowledge of software engineering and computer operations, RF is a server and is accessible to the public. He said he was aware that the information or data generated or inputted in the beavers were operating online or offline, were transmitted to the ANEC servers, including virtual servers hosted on AWS Cloud. On cross-examination of the first respondent, however, the witness admitted that his opinion was based purely on his reading of the Electoral Act and ANEC guidelines, and that he was not familiar with the applications and operations of the beavers machine. He stated that he did not play any role in the election. Indeed, as admitted by the witness, the statement, particularly paragraph 10 to 13, is a virtual reproduction of Section 38 of the Electoral Act 2022. On cross-examination by the fourth respondent, he admitted that he did not state his educational or professional qualification or experience in his statement on oath. He also stated that his investigation was based on publicly available application program interface, API, and collected information through it, like from EC8S. He said he did not have the documents and forms he used and that everything was in his laptop. Contrary to the speculation of the petitioners that ANEC was not prepared to conduct the promised credible, authentic, and transmitted election, or that it deliberately or mischievously allowed the compromised IT infrastructure to be deployed for the conduct of the presidential election, PW2 confirmed that Amazon Web Services is the most secure service providers in the world, and that it is used by corporations, companies, individuals, and governments that are most concerned with security. In his entire evidence, PW2 did not talk about the contents of any result. Instead of supporting the petitioner's allegations, the evidence of this witness supports the case of the first respondent. As for PW3, PW5, and PW6, he merely tendered flash drives containing speeches of the ANEC chairman, Mahmoud Yakubu, and ANEC National Commissioner, Festus Okoye, wherein they gave assurances that results of the election will be transmitted to the RF for public viewing. Being mere assurances, the evidence of these witnesses had no utilitarian value in establishing allegations of corrupt practices made by the petitioners in this case. In his evidence, PW4 tendered exhibits PCD 1, 2, and 3, which he claimed to be the report of his analysis of the presidential election. The witness also tendered 4 boxes containing what he called 18,088 blood polling unit results downloaded from the RF portal, which were also admitted as exhibits PCE1 to PCE4. However, in the earlier ruling of this court on the respondent's objection, we have struck out exhibits PCD 1, 2, 3, as well as exhibits PCE 1 to 4, along with the witness statement on oath of PW4, which was not filed along with the petition since the documents were tendered through the incompetent witness. The witness claimed in his evidence that from his investigations, the scores on forms EC8S of 39,556 polling units were inaccessible as they contain uploads not connected with presidential election, and that the number of accredited voters affected by the 18,088 blood result was 2,565,269, while the number of voters who collected their PVCs was 9,165,191. According to him, this signified that the votes of 5,533,553 accredited voters were discountenanced by the first respondent. He added that 23,119,298 registered voters collected their PVCs in those 39,546 polling units, and concluded that both the number of accredited voters of 5,553,553 and number of voters who collected their PVCs of 23 million plus polling units far exceeded the margin of lead from the first respondents' announced result of 1,807,206 over the first runner-up and 2,693,193 over the second runner-up. PW4 also stated that in Benue State, neither the results he obtained from the RF nor the CTCs of Forms EC8As matched the results of the first respondent. He stated that the annex CTCs of Forms EC8As showed that LP got 272,468 votes and APC got 256,852 votes, while the results from the RF portal showed that LP got 260,796 votes, while APC got 268,630 votes. He added that the ANEC announced result showed that LP got 308,372 votes and APC got 310,468 votes. He concluded that by adding uncovered votes and deducting votes affected by overvoting, manipulation, alteration in Benue State, LP got 281,426 votes, while APC got 258,683 votes. A look at the 18,088 blood polling units results, which the witness claimed to have downloaded from the RF portal, showed that they were not certified by the first respondent. Being secondary evidence of public documents, they are clearly inadmissible. See Section 89E and 90E of the Evidence Act 2011, case of Emeka versus Ipiazu, others. Of note is that PW4 admitted under cross-examination by first respondent that the primary source of the data he used in his investigation is from the RF portal. This clearly means that he based his investigation on inauthentic data, since the essence of certification of public documents is to ensure authenticity of public documents. See the cases of Ebwe and Araka and Emmanuel versus Mana. Also under cross-examination, PW4 stated that his reference to Form EC8A and the result on RF portal are not the same thing, and that Form EC8A is a paper, while the result on RF is a copy of it. He particularly admitted that by his reference to blood Form EC8As on the RF, he was not suggesting that the hard copies of Form EC8As are also blood. This admission by PW4 also dealt a death nail to the allegation made by the petitioners in paragraph 60 of the petition that the first respondent suppressed the first respondent's cause in 18,088 polling units by deliberately uploading unreadable and blood forms EC8As on the RF. In fact, PW4 had under cross-examination completely rubbished his own report when he admitted that the RF portal is not capable of collecting and tabulating the election results, and that it is the image of the Form EC8A that is transmitted to RF, while the hard copy of Form EC8A is taken to the collation center, which he stated is collected at the local government, state, and national collation centers. He also admitted that since the result in the Form EC8A is taken to the collation centers, the failure to transmit its image in RF or that image transmitted its blood will not change the result already entered in Form EC8A. Again, the witness admitted under cross-examination that his report in exhibits PCD1, PC2, and PCD3 only covered the two states of Rivers and Benue, and that he worked on only available data, that if he had more data in his report, would have been different. He further admitted that his report, Exhibit PC 1, 2, and 3, is not a product of expertise, as any secondary school student can do the simple arithmetic involved in it. This admission by PW4 effectively rubbishes his entire report as inconclusive and manifestly unreliable. On the whole, the evidence of this witness, even if it were to be considered void of any probative value. As for the evidence of PW7, we had earlier analyzed and evaluated her testimony and found that she was not only a person interested in this petition. A report in Exhibit PCJ 3A to F, which she brought to the court purportedly as an expert witness, was merely downloaded by her from AWS site, which was openly accessible to the public. Her evidence is also of no probative value. With regard to the evidence of PW8, I have earlier analyzed and evaluated his evidence while resolving issue 2. Suffice it for me to state that I had found that PW8, having admitted that in the course of his commissioned work, he had read the petition and the first respondent's reply, as well as the Electoral Act and annual regulations and manual, and that he finished his final report in May 2022 during the hearing of his petition. PW8 had practically worked to a predetermined answer, and his evidence was of no probative value. PW9, who gave evidence as an accredited observer of the election, had stated that everything about the election in the polling unit, which he observed when as accreditation and voting took place, the votes were counted and the results were announced and recorded on Form EC8A, but was not uploaded on the RF at the polling unit. Under cross-examination by the respondents, he stated that from his observation, the election went on smoothly in his polling unit and that the election officials complied with the ANEC regulations. He stated that the result was taken to the collation center by the election officials. Rather than support the petitioner's case, the evidence of this witness actually reinforced the response case that the election was conducted in substantial compliance with the Electoral Act and ANEC regulations guidelines. PW10 stated that he acted as an ad hoc supervisory presiding officer for Madagali Ward, and that on election day he collected the materials with security agents and other ANEC ad hoc presiding officers. He stated that voting went on well until 6:30 p.m. and all voters who were on queue by 2 p.m. duly voted at Unit 004 DISA. He stated that after sorting and counting of the votes, the presiding officers did the entry and snapped the results with the beavers, but were unable to transmit and upload same to the RF portal after the result of the National Assembly election was uploaded. He stated that when the presiding officers complained to him, he asked them to come to the registration area, where he requested them to meet the registration area center tech, who asked them to submit the beavers to him for transmission, but was unable to upload. On cross-examination by the First Respondent Council, PW8 stated that apart from the small issue between agents of APC and PDP, which was satisfactorily resolved, everything went well and the results were entered in Form EC8S in the units and were properly announced. He added that the physical copies of the Form EC8S were taken to the Ward Collation Center. Cross-examination by second and third respondents, the witnesses have confirmed that notwithstanding the difficulty in uploading the results, the collation of Forms EC8A took place in the ward. The evidence of this witness also supports the case of the respondents rather than of the petitioners. PW11, head of the Legal Services National Information Technology Development Center, NIDA, merely stated that he was subpoenaed to produce and tender the following documents. A. Correspondence of documents, letters, emails sent by him, or from Independent National Electoral Commission to National Information Technology Development Agency requesting for the IT clearance approval of the IT infrastructure to be deployed and or deployed by ANEC for the conduct of 2023 general election. B. The certificate of clearance approval issued by NIDA to ANEC pursuant to any request in in A above. 3. The report submitted by ANEC to NIDA containing certification for the testing review of the IT infrastructure deployed for the conduct of the 2023 general election. It stated that they don't have any of the documents in their office. Under cross-examination by the second and third respondents, he stated that the NIDA Act does not contain cyber security standards. He also stated under cross-examination by the fourth respondent that their supervisory ministry is Ministry of Communication and Digital Economy, and that the minister stated that there were 16 million attempts to hack the INEC IT infrastructure on the day of the election. The evidence of this witness is of no assistance to the petitioners. PW12, the petitioner's star witness, whose evidence was merely a copy of the averments in the petition, stated that on the day of the election, he voted at his polling unit at Dawaki, Abuja, after which he went to the situation room of his party. The second petitioner, he stated that apart from his polling unit and the situation room, he was not present physically at any other place on the day of the election. He stated that he was not a collation agent or polling agent in any polling unit or collation center. His evidence in chief was therefore mostly laced with hearsay. Settled that hearsay evidence inadmissible and has no probative value. Apart from his evidence in chief being inadmissible hearsay, Exhibit X1, a certified true copy of the judgment of Federal Court Abuja in suit number FHC ABGCS 1454-2022, was tendered through him under cross-examination by the first respondent, and he read out a portion of the judgment of the court, which was to the effect that the first respondent was under no mandatory obligation to electronically transmit or collate results of the election. He also admitted that he did not state in his statement on oath any figure unlawfully ascribed to the second respondent and third respondent by the first respondent. He also stated that his party had agents throughout the federation with over 133,000 votes. When asked by the second and third respondents' council to state the score of the Labour Party, the witness stated that he will not know scores of the Labour Party because the results are being uploaded on the IREF. He added that he will not know the unlawful votes accredited because he is not an expert, and that the wasted votes are part of the statement made by the expert. When cross-examined by the fourth respondent, PW12 said he was not aware that ANEC chairman had given a statement that ANEC will not transmit results electronically. When confronted by the fourth respondent's counsel, he confirmed that his statement on oath wherein he stated that he will rely on the evidence of forensic experts was made on 20th March 2023, while the final expert report he was relying on was made in May 2023. Clear that PW12 relied on an expert report that was not in existence at the time he made his statement. Obvious that the evidence of this witness lacks credibility and is therefore manifestly unreliable. PW13 was the only presiding officer called by the petitioners in this petition. His evidence was that in his polling unit 035 at Open Field Ward 04, Chikun local government area in Kaduna State, the election went well, and that thereafter all efforts to upload the presidential election results as captured in Form PC8A failed except the National Assembly results. That when all efforts failed, he proceeded to the collation center with other ad hoc staff. When cross-examined by first respondents' counsel, he stated that he recorded the results manually, and the only problem he had that day was the uploading of the result. That when he could not upload the result, he called his supervising officer, who told him to take the result to the ward collation center, which he did. On cross-examination by second and third respondent counsel, he confirmed that after recording the result manually, he signed and the party agents also signed. When cross-examined by the fourth respondent, he stated that after signing the result, he gave copies to party agents. The evidence of this witness actually supports the case of the respondents that the election was conducted in substantial compliance with the Electoral Act 2022. In Buhari and INEC and others, the Supreme Court clearly stated law as follows. Quote, a petitioner who contests the legality or lawfulness of votes cast in an election and the subsequent result must tender in evidence all the necessary documents by way of forms and other documents used at the election. He should not stop there. He must call witnesses to testify to the illegality or unlawfulness of the votes cast and prove that the illegality or unlawfulness substantially affected the result of the election. The documents are amongst those in which the results of the votes are recorded. The witnesses are those who saw it all on the day of the election, not those who picked the evidence from an eyewitness. No, they must be eyewitnesses too. Both forms and witnesses are vital for contesting the legality or lawfulness of the votes cast and the subsequent result of the election. One cannot be a substitute for the other. It is not enough for the petitioner to tender only the documents. It is incumbent on him to lead evidence in respect of the wrongdoings or irregularities both in the conduct of the election and the recording of the votes. Wrongdoings and irregularities which affected substantial result of the election. Proving an election petition or proof an election petition is not as easy as the Englishman finding coffee on his breakfast table and sipping it with pleasure, particularly in the light of Section 146(1) of the Electoral Act. The petitioner has a difficult, though not impossible task, close of court. See Mohammed and another for Sultan Ladi and others. In this petition, where the petitioners have labeled several allegations against the first respondent, such as suppression of votes, unlawful reduction and inflation of results, uploading of fictitious results, misrepresentation, manipulation of results where no election took place, and wrong computation of results, it is evident from the above that the petitioners have not laid any credible evidence to substantiate those allegations. Of the 13 witnesses recalled, only 2 are presiding officers who were present at the polling, who are present at their polling units. Hence, the petitioners have not been able to establish any of those malpractices which they allege. The evidence of the witnesses which the petitioners call as experts to try to establish that the first respondent is mandatorily required to transmit election results for the purpose of collation or to link the delay in the upload of the presidential election results to average by the first respondent to any of the malpractices which they allege are devoid of any value. The petition allegations have remained mere speculations and unfounded accusations. The petitioners have failed to establish beyond reasonable doubt the corrupt practices which they allege as required of them under Section 135(1) of the Evidence Act 2011. On the petitioner's allegation of overvoting, Learned Counsel for the first respondent contended that to prove overvoting, the direct record of accredited voters and the beavers machines are required alongside the voters register of the affected polling units. He pointed out that the petitioners failed to produce the beavers machines and the voters register. He submitted that the petitioners want this court to rely only on the expert opinion of PW4, which is not credible. He submitted that when PW4 was confronted with the results in polling unit 002 of Ward 7 of Degema, LGA, River State, which was part of his report on overvoting, in Exhibit PCD2, he stated that there was no overvoting, as the number of votes cast was 40, while the number of accredited voters was also 40. He relied on Oyetola and INEC at this court to discountenance PW4's evidence of voting. The petitioner's allegation of overvoting is contained in paragraphs 72, 76, and 77 of the petition, which have been produced here. In the area ruling of this court, the respondents' various preliminary objections